The following is a pre-recorded show. Welcome to Winning in Retirement with your host, Brian Akers, certified financial planner professional and founder of Akers Financial Group. Now, helping you win in your retirement, here's Brian Akers.
Welcome to Winning in Retirement. I'm your host, Brian Akers, certified financial planner practitioner, president and founder of Akers Financial Group. And we welcome you to our show today. Today we have a very special guest for you, and this show is going to be one of your favorite shows you've ever heard because we have Kevin Bress, a local attorney that we had worked with for many years. Kevin and his partner, Ashley Rout, own a firm called Bress Rout Law in Bel Air, and they also meet clients in Towson. Welcome to the show today, Kevin. Good morning.
Good morning, Brian. Thanks for having me.
It's great for you to come into the studio here and talk estate planning. And now today, I'm going to mess you up a little bit with the way I'm titling the show.
Thanks, Brian.
Because of your experience of, I believe, 40 years or 400 years experience, something like that. And I'm sorry, I shouldn't have said that. But I came up with this title called Estate Planning, and much more, just to be funny and to make this something about lots of topics. And so I was going to call it The Attorney in the Corner, and where Brian Akers is going to grill the attorney with as many questions as he can get out in a 1-hour show.
Yeah, I'll limit it to billing you just for the hour.
That's good. Not by topic, right?
Right.
All right. So yes, attorneys. The hardest part sometimes is you hear the word, you go, Kevin's one of those attorneys that he's actually a nice guy. He's brilliant, nice guy. Is that true?
You forgot the looks.
Oh, the looks, of course. He is beautiful for radio. No. Kevin actually comes to a lot of our events that we have for our company. AkersFinancialGroup.com is our website. On there, we have our events that we do throughout the years, and Kevin's been a speaker at those. But Kevin, today's show, we got to get going because I have a lot of questions for you, and I think it's a great opportunity for you to share your wealth of knowledge with our listeners on winning in retirement. I believe that winning in retirement means that everything is taken care of. That means you've done the hard thing, which a lot of times is estate planning. Now, I want to start with just a basic question, and that is, how do you decide between things such as wills or if somebody needs a trust? Is there a certain guideline that you do as an attorney?
It's interesting. My first line to my clients when they sit down is, let's start with the premise we're going to keep this as simple as possible, the estate plan. But then as we start peeling off the layers of what their family issues are, do they have a child with special needs? Do they have a tax problem? Then we layer on sometimes a trust. So we don't start off saying, here's what trusts can do for you. I'd rather hear from them why they need one.
Right. So there's trust and then there's wills. Can you explain the basic difference between them?
Sure. A will is the most common, simple way of dealing with the distribution of your estate when you die. It says, everything I own gets whacked up this way.
Sure.
Instead of a will, you can have a trust that essentially does the same thing, but it has extra work involved with it, moving the assets into the trust and setting up a separate document that people are always a little unsure what they're getting themselves into.
Right. But then the trust costs more than a will based. Now, the other argument might be that when a will is used, that means the person has to go through probate, and then there's might be more fees later because of that. So can you explain the basic of what the word probate means and a little bit about that?
Yeah, probate, here's how I do it, Brian. There's 3 ways your assets pass when you die.
Okay.
They're either jointly owned and they go to the spouse.
Sure.
Let's say the house goes to the spouse.
Okay.
They're beneficiary designated, like IRAs, life insurance. You can do it on banks and brokerage houses. So joint beneficiary goes to that directly, but everything else has nowhere to go. So it goes to your estate. And the government says, we want to make sure that money goes where it's supposed to. So they have a whole body of law called the probate laws and procedures.
Okay. And that's where one of your many specialties over your career has been estate planning.
Absolutely.
And estate planning has changed over the last 40 years.
It's actually in many ways gotten easier.
Okay.
But luckily, I've broadened my client base to where now I'm getting the complicated cases because the easy ones don't need to come in.
Yeah. Right. The easy one, there's an answer. And then when the more complex, the more questions and more complicated answers, then the solution is more complex. Now, one of the things that makes it complex over this year, 2025, and next year, 2026, is the fact that there's a Tax Cut and Job Act that affects the estate tax law on the federal level. And I wanted you to try to explain where federal estate taxes, where the taxation actually kicks in, like what level, and basically your thoughts on the sunsetting of the Tax Cut and Job Act, and if there's anything people should think about.
Yeah, it seems, Brian, when Congress passes these tax code changes,
sure,
they put a sunset provision on them to say, well, this is only going to last for 10 years, and then we'll renegotiate the tax law. So we're up against that in 2026, January 1. Mm-hmm. And what will happen is this very generous $13 million exemption of what you can die with without a tax is going to probably be rewritten by Congress if they can ever sit down and write something and pass it. So we have no idea whether that 13 million will stay the same or go back to what it should be or even go lower.
Yes, that's very true. We don't have a clue. But in planning, the hardest part is you have to plan within the rules, but then your documents have to give the flexibility if they do change the rules. So is there a way that you guys do plan for that in your documents?
Well, not so much the documents, but talking to clients. So you and I were talking about how fortunate we are to have some extremely wealthy clients that we help. And one rule is, hey, guys, the exemption's $13 million today.
Right.
If you want to give children $10 million tax-free and then the exemption drops to $7 million, you got away with something because you're grandfathered on the big gift.
Right. Okay. So that would mean that the sunsetting of the law, planning and gifting and legacy concepts, enacting those now would make sense. And that's why you would need advisors, an advisory team, usually comprised of financial advisors, attorneys, insurance specialists, and accountants. And you bring that group where you work on what's best for your overall family plan. That's
right. And many of the times those advisors are a company like you guys do. They accompany their clients to the meeting, which is so good.
Yeah, what we try to do is do financial planning. As part of the planning, have a discussion on their estate. As we draw that up, then we figure out what they need to do. We have the client, if they have attorneys, they go back to them. If they need other attorneys, we give them a list of people. And then the idea is that they choose who to work with. Then when they do that, we try to be involved to relate what the client told us and what the attorney needs to know. And then we usually produce documents of where the clients, all their assets are, because lawyers can spend a lot of time in discovery where as a planner, I can bring that in right at the first part of the meeting, which makes the attorney job a lot easier, I'm hoping.
It's funny you use the word discovery, like interrogatories and depositions.
Hey, I've been watching law shows, so I know everything about law because I've been watching on TV.
Yeah.
No, I think it's amazing each concentration of people's jobs, and I love to hear how people work and how it all comes together. The thing about getting older is the more you know, the less you really know. When you're younger, you think you know everything because you know everything about that one thing. Maybe. But as you get older, you don't know everything. What's great about financial planning is you discover about the client. Then you got to go figure out what is best for that person, and you need experts to work with. Now, when I'm talking to Kevin, there's this one topic recently that I want to make sure the listeners understand it, and that is there's a federal limit of 13.61 for 24. That's $13 million per person can pass without federal estate tax. But then Maryland isn't at the same level. So if someone passed away, they're a resident of Maryland, they might be exempt of federal, but have a Maryland estate or inheritance tax.
Right. A single person has an estate tax exemption for the first $5 million.
Okay.
If you're married, there's a way to make that turn into $10 million.
Right. Through something, I think you used the word portability.
It's an election. You've got to file the right paperwork.
And And that's done after the person passes away or in a will?
You basically should be doing it within a year of the first spouse dying.
And that's not inside your will or inside of a trust. That's separate.
Totally different. And it's an arduous task to do it. It's a 20-page tax return.
Sure. Okay. And so that's all tied to portability, to be able to separate the assets, to be able to take the double exemption
to $10 million
and to hold. And that's for Marylanders that have been very successful. Now, an estate could be everything from our houses going up to life insurance to investments to retirement accounts. All that adds up to be your estate.
Everything you have control of is counted.
Absolutely. Yes. Yeah. So my dog would count. So.
Change in your pocket.
Right. Change your pocket account. So the idea here is this. There's attorneys, there's financial planners. They work together, and they work together to help take this information and apply it to your situation. At Akers Financial Group, we talk about unique financial fingerprint. It applies to your estate planning. And the more successful you are, the more you have built your wealth over time, the more you're ready to win in retirement, you got to make sure you have these things set up. And you got to make sure they get them all in order, right, Kevin? I mean, people have to get these things done. And
that's why they don't, because they say, I got to get to that, but I'm just not ready. I haven't thought about it enough yet.
Is that more because they don't like to talk about death? Or it seems like if you do the planning, you're shrinking your lifespan, or what goes on?
No, I think it's just deer in the headlights, Brian. I think it's just they know they need to do it, but they just haven't really gotten the gumption up to do it yet.
Yeah, well, that's a very important thing. And while you listen to Winning in Retirement as you're driving around or just listening on to podcast radio, what I want you to do is think about winning in your retirement years. You need to take care of things that you haven't taken care of so that you can relax and be stress-free during your retirement years. At Akers Financial Group, we are a local, an independent firm. We don't report to a big company on Wall Street. We report to you. We have offices in Lutherville and Forest Hill, clients all around this Mid-Atlantic region, around the country, and even a few around the world. It's so easy to begin winning in retirement. Just give us a call and schedule your free meeting with one of our team of advisors by calling 833-WIN-RETIRE. That's 833-WIN-RETIRE. We'll give you a call on Monday to schedule your free in-person meeting. Go to AkersFinancialGroup.com or call us at 833-946-7384 to start planning for your retirement now. Retire to another state? Are you legally ready? We'll talk about this when we return in a moment.
You're listening to a pre-recorded show. Welcome back to Winning in Retirement. Call 833-WIN-RETIRE now to schedule a visit with Brian and his team and begin winning in retirement. Once again, here's Brian Akers.
Welcome back to Winning in Retirement. I'm Brian Akers, certified financial planner practitioner from Akers Financial Group. And here with me today is an attorney, Kevin Bress, and have known Kevin for a number of years. He's an expert attorney who's been practicing in the area of estate planning for more than 40 years. He and his partner, Ashley Rout, have a law firm, Bress Rout Law, LLC in Bel Air, and they also meet clients in Towson. Kevin's been a great resource, and he's been on the radio show a few times over the years with us. He's here again today. This is the second quarter, so we're diving deeply in with our questions. I've called our talk today the estate planning, and much more. And the reason is I wanted to talk about a lot of things, and this topic is very important this quarter because we're going to start with a simple one. If someone retires to another state, or if they retire to Maryland, and they had legal documents where they were, what do they need to do? That's my first question, Kevin. I'm sorry, it's a tough one.
Well, it's a good news, bad news answer, as lawyers always.
Are you going to say it depends?
It depends on one hand. And
okay.
Yeah.
I want concrete. Yeah.
So what's concrete is the Constitution of the United States says that each state shall give full faith and credit to the laws of other states.
Okay.
Anything valid in Maryland should be valid elsewhere and vice versa.
I want to play music to that.
Star Spangled Banner. And the bad news is that there are 50 different sets of laws that even though your Maryland document may work in Pennsylvania or Florida, They might say, well, down here, you got to do things a little differently, and your will is going to slow it down because you didn't do it the Florida way.
Right.
Florida wants a notary. Maryland doesn't. So that's one example.
Right. And Florida, what we found is a lot of people use trust as the way to try to make it a little easier. Yeah,
it's at the South Carolina or Georgia border that, you're entering trust country.
Yeah.
As you go into Florida.
Definitely. So the first thing is retiring to another state. So let's say they're retiring to Maryland. So let's have a hello, welcome to Maryland, and they come into your office with copies of their documents. Is there a certain things that Maryland does different?
The powers of attorney, Brian.
Okay.
It surprised people that's the sticking point. Maryland has a very defined way your power of attorney should look, and then it's bulletproof if you do it that way. All bets are off if you take it somewhere else.
Sure. So power of attorney needs to be reviewed, most likely redone when you move into a state, or at least into Maryland. This is what we're calling, because you're licensed in Maryland.
Yes.
Have you ever been licensed in other states?
No. Don't want to go there.
Because that they have to take bar exams per state, or there's some special exclusions, I believe.
And in a way, that's the easy part, because once you pass the bar, it doesn't mean next week they change the law and you're aware of it, because you're sitting down here in your own little ecosystem.
Right.
Yeah.
All right. So we've talked about basically moving to Maryland, power of attorney being very important. I know there's some passionate topics of yours, and that is about the living will. And about cars having beneficiaries. Do you mind just mentioning that topic before I hit you with a few more questions?
Well, living will came back around the 80s, and it was a one-page declaration that said, if I'm in this condition, kill me. Now, they use better language than that in the document. But this is radio. I got to get the message out.
You got it out. Yeah, you did.
So the health departments all over the country have said that living will is gone. Don't use it. We have a new document that says, "If dear doctor, here's when you can pull the plug."
Okay, and what is that document called?
That's a MOLST form, MOLST, Medical Orders for Life-Sustaining Treatment.
All right, let's go slow. MOLST, MOLST.
You can't say it with food in your mouth; it'll just come right out.
It is MOLST.
Correct.
Say what does it mean again?
Medical Order for Life-Sustaining Treatment.
All right. So with that, then that would be the instructions. So I get rushed to the hospital. Am I supposed to dive to my safe and bring my document running in, or how does that work? Because I picture that the worst case day, I'm not going to know where my document is. What goes on?
So Maryland is cool. Maryland's ahead of the pack.
Okay.
Maryland says take your advance directive, upload it to a site, and it can be downloaded anywhere in the medical community in Maryland. You're probably going to need it.
So a doctor would have access to that when let's say you get wheeled in and you're unconscious. She would be able to see that already?
Type your name in and your date of birth, and it'll say medical directive on file. Do you want to download?
Because I've had clients come in and say, well, when I went to the hospital the other week, they had me sign a form. They had a hospital form like that.
And now when we do it as a lawyer, we do what we hope and think is a better form than the hospital's filing cabinet form. And we say, upload this, and the hospital will get it directly. You can forget to bring it. They will get a hold of it for you.
All right. Now let's talk about cars. I've had some people where the only thing that didn't have a beneficiary was their car. And so then they had to open an estate and get a letter of administration and then get their car transferred. And now there's a way through the MVA site.
Our MVA has nice things, but they don't tell you about them.
Okay.
So they have a beneficiary designation link on their website that lets you click, title of your car, $20 credit card payment, and they'll mail you a new title, and a beneficiary will be on that title.
So you actually get a new paper title.
Yeah, throw away the old one.
It's just online.
All online. I did hear a client tell me they walked in and did it. I wasn't sure if you could walk in.
Okay.
But apparently you can.
And that's on the Maryland Vehicle Administration's website. You type in under the search engine there, a beneficiary.
Or from Google, if you type my MVA space Maryland, the link will help you get there.
Wow, that's deep. All right, now I got to go harder questions. I know you love those topics. Now the harder one. The harder one is this. There is these words: estate, inheritance, income taxes, fees. There's custodian fees, fiduciary fees. Do you mind going over like some of the difference between estate tax, inheritance tax, and all that kind of concept for us?
Yeah, for death.
As simple as possible.
You're right. For death, Maryland has two possible taxes.
Okay.
They have the estate tax you and I were talking about in the first segment, that you have to have $5 million to even worry about it.
So someone has $6 million when they do the full accounting, and you subtract 5, there's $1 million.
Taxable at 16%.
So 16% estates, that person would pay, not them, but their estate would pay $160,000 to the state of Maryland for estate tax.
If it's not going to a spouse, correct.
Okay.
So that tax, 160 is a big check.
Correct.
Even though 16% and, I'm only a little over 500,000. $5 million. The next tax is called the inheritance tax. So Maryland has two different death taxes.
Sure.
A lot of people don't realize. That's a 10% tax, and it's not about how much money you have. It's what's the relationship of the people you're leaving it to.
Sure.
90% of us are leaving it to exempt individuals. So nobody's really crying about this tax. Exempt are your spouse, your children, your grandchildren, your brother, your sister. Non-exempt, your niece, nephew, cousin, friend, or somebody you've been living with for 20 years. But now Maryland has a domestic partner registration, and for $25 at the Register of Wills office, you can get them to waive the 10% tax.
They can do that at the Register of Will of their county of residence
Exactly.
or city. They can go there.
Yep.
All right. So that inheritance tax, you said there's two. There's a 10%.
10% and 16, and you pay the greater of the two. So if you die subject to both taxes, you're not paying 26%.
You're not paying 26. It's one or the other.
That's right.
And so if you're the nephew and the state's only $1 million, not $6 million, it's lower. Only $1 million, still wonderful. But that $1 million would get a 10% tax.
That's right.
How is that paid?
Well, there's two different ways. If it goes through probate, it's at the end of probate, so it's months and months and months.
Like 9 months.
I have an estate right now that doesn't go through probate, revocable trust.
Right.
Well, as soon as the Register of Wills hears revocable trust, they send a bill out and they give you 30 days, otherwise 13% interest rate.
So what do you mean by that? Could you explain that to me?
You have to pay that inheritance tax within 30 days of the bill coming out.
Sure.
Where they start accruing what I would call usurious rate of interest.
Yes, so that's a revocable trust, and that is if you retitle it to irrevocable upon a death. Is that what you're saying?
I'm saying if the beneficiaries of that trust, whether irrevocable or outright,
sure,
are not exempt beneficiaries the way we were talking, so it's a cousin,
sure,
then the Register of Will says, we're sending a bill to that person directly.
And the Register of Will finds out by when you re-register it. Is that true?
It really comes out if there's probate, because probate has a whole bunch of forms. So you make a good point. There are a lot of people who, if they don't call the lawyer and say, what am I supposed to do?
They might not pay it at all.
They might not pay it at all.
And then someday later, they get a little letter in the mail, and they might not open it. And before they know it, they owe this money.
Or they go to sell the real estate, and the title company says, wait a minute, you didn't pay the tax.
Yeah, that's a big deal when you get your aunt's house, and all of a sudden, you finally ready to sell it. You got to retitle, and you're like, oh my, I got all this to happen. Okay. So I just wanted to cover just some of the issues I've heard from clients over the years of what's going on. Now, we talked about estate tax, inheritance tax in Maryland. We did not talk about income tax. That also is possible when someone passes away, depending on how the person receives the assets, such as retirement accounts, non-qualified annuities. Those are taxable to the beneficiary as income tax. And so those are other things, and there's fees and all that. I know there's a lot to talk about. That's why we have an hour-long show. All we've done so far is cover our estate part of it. We got much, much more to cover as we keep going. So today, as we're talking about this, you can always go to our website at akersfinancialgroup.com, and you can find out more right there. You can also check our events page right there and see about events that are coming up so that you can be involved in, and you're all invited to those. Also, when we talk about planning and estate planning, we believe that in a team of advisors will truly help you reach your financial goals. I like to say that if we plan as if we might die tomorrow and then invest like we're going to live forever, things are going to be well taken care of. So at Akers Financial Group, we invite you to take advantage of our time, to be able to meet with us for a free consultation about your situation, your unique financial fingerprint, because that's what's going to determine where your money goes and how you title things. It's not about us or what we want to do for you. It's about whatever you need for you and your family. So give us a call at 833-WIN-RETIRE. Schedule an in-person meeting with one of our team of advisors. That's 833-WIN-RETIRE, 833-946-7384, and visit our website, akersfinancialgroup.com. Are you single or a widow and doing your estate plan? What are your choices? We'll talk about this in a moment.
You're listening to a pre-recorded show. Welcome back to Winning in Retirement. Call 833-WIN-RETIRE now to schedule a visit with Brian and his team and begin winning in retirement. Once again, here's Brian Akers.
Welcome back to Winning in Retirement, the Akers Financial Group's radio podcast. We welcome you very much to the show. Our special guest, Kevin Bress. Good morning, Kevin.
Good morning, Brian.
We're here in the second half already.
The halftime show was great.
Yeah, let's not talk about the halftime show too much. We don't want to have too big of a crowd here. We have a big crowd. We have at least one person watching at the moment. So the idea is this. We do a radio show, Winning in Retirement. Why do we do a radio show? Is so you get to know what we think, how we work with people. We invite special guests that we have worked with over the years, and Kevin Bress and his firm is one of them. And we invite them to come in and bring their expertise to our topics. Our topic today is truly estate planning, and much more. Hey, this third quarter is the much more section of my title, and the much more is all involving this quarter about, are you single, a widow, or doing estate tax, or having that you need an estate plan and you need to really think about what's going on. We found that over 60% of people retire single as a divorced person, a widow, or just single their entire life. And so that's specialized planning there. So, Kevin, what's your basic idea when it comes to people that are single and trying to do estate planning?
It raises a lot of different issues, Brian, when you're single. First is the mere fact that you don't have a spouse to leave everything to. So normally when there's two of you, it's just like they play off each other. It's right. No problem. But now reality sets in. They need to get their estate planning in order. And we have to face reality because these are often more senior people. You know, they've lost a spouse potentially, and they don't realize that their mental capacity can diminish over time and they can be taken advantage of. So they need their assets ready to be sort of protected and locked up. Mm-hmm. And there's vehicles for doing that.
All right. So there's different singles that have no spouse and no kids at all. And then there's ones with kids.
Sometimes that's worse.
With kids, yeah.
Because they're vying for mom's money, you know, the daughter versus the son.
Right. And are they vying for the money? Are they truly caring? Are they not caring?
That's right.
And then another example would be there's relatives, but not any direct line.
Right.
Like you use the word exemption or exempted people under Maryland. Basically, if you're under the exemption, there's no inheritance tax, but there might be relatives you want to give it to. And then there's if you want to give things to charity. So let's go over some basics of that. I know that in my examples of no kids, relatives are given to them or nobody at all, there is this taxes that could occur depending on who you give it to.
And there's a big question of who's paying that tax, Brian.
Yeah.
The estate could pay it off the top and then hand the checks to everybody, mm-hmm. or everybody gets a bill in the mail. And that has to be explained. And if you looked up the estate of Tom Clancy, you can see that was a multi-million-dollar alleged mistake the law firm made by not drilling down on that issue.
Tom Clancy is a Maryland novelist.
He was a Maryland, Baltimore resident when he died, and his estate was administered right here.
Right. And so what would you say the basic problem was with that estate?
Basic problem was failing to remember that his ex-wife was getting a ton of money, generating a ton of tax, because she was an ex-wife.
Okay.
And yet the children had to pay her tax for her, which, it's their mother, but money's money.
Yeah, because an ex-spouse cannot just roll over IRAs into their own name.
Right.
If they pull the money out, they pay income tax. And so it sounded like that ran through the estate too, because in some of the estate documents, they write the estate will pay all the tax, right?
That's right.
Yeah, okay.
And sometimes that's a mistake. Rarely, but sometimes that's a mistake.
All right, so let's have a sample where a person comes in, they're single, and they have no relatives at all, and they're just trying to figure out where to give money. Now, if they decide to give it to a friend, is that different than a relative?
You mean in terms of the tax or just in general?
In any way. Yeah, I'm just giving you a softball question. Actually, it's hard now.
Well, friends are hard to find.
Okay.
Because I have an estate now. The woman's will says my godson.
Sure.
Well, that's no relationship. Right. And this guy's in the wind, not like from the law, but he's in the wind. And he has a fairly common name. And the question, if he was related, we'd say, oh, well, let's call the aunt and she knows where the nephew is, or let's call the sister. So, yeah, friends can pose challenges without more description of where they are.
Right. So friends, you need on your wills and documents to have their addresses, phone numbers. It'd be very good if you had a section in your house or a place in your house where you kept that information all in one place.
Yeah. That
would be good for the person to follow, because we don't know how we're going to pass away. Should it be suddenly or slowly? When we're a single person and that single person wants to decide who gets the money, a lot of times they want to make sure they get the money. They might want to bypass their sister and give it to their nephew. And one problem with that is if they gave money to a sister, there's no tax, but to the nephew, there is tax.
And that's when I say, well, if you trust your sister,
right,
give them the money, give her the money, and say, please give this to your child, because the gift is probably tax-free.
If you go that way.
Yes.
Now, how about, I'm just going to, when you adopt a kid, are they included under the exempt section?
They are. We actually had a brother adopt a brother. Crazy. Okay. So one was the parent brother and one was the child brother. And that way, whoever died first, they would receive all the money of the other brother tax-free.
Tax-free. Okay.
And it was $1 million plus, so they just didn't want to see 10% come out twice.
How about a stepchild?
Tax-free.
Okay, so like if you have a second marriage and they bring, like Brady Bunch, bring kids in, that's still tax-free in Maryland. Okay?
Yeah.
There's no special thing you need to do for that.
Right. They are not literally a stepchild as far as the taxes concerned.
And that continues to step grandkids also?
Down the line. Oh, no.
Sorry. Yeah.
Yes.
I didn't know the answer. I'm not trying to trick you or nothing.
No, but the word step snuck through. Yeah. Step grandchildren, 10% tax.
Okay. So it's just that one level.
Yes.
All right. So when someone comes in, they're a widow, and the widow, they might be great with finance. They might not be great with finance. And let's say as an attorney, you see that they're not great with finance. Is that when a trust makes sense, or what kind of thoughts goes through?
Definitely a trust. If they were open to as much protection as possible, I would say to my client, why don't you name a co-trustee now? And that way they're already on all the financial documents with Akers accounts.
Right.
And then if they suddenly have a stroke or something, the co-trustee is able to act by themselves and they're already on all the accounts.
Let's say they don't trust their kids, but they need a trustee, and then there's corporate trustees out there. Have you ever worked with corporate trustees?
They're challenging, Brian. I'm going to be honest, because it is a business for them.
Sure.
They are housed in big cities sometimes. They have turnover. So whoever your trust officer was could change.
Sure.
So what I recommend is put in your document a person to serve as what I call the trust protector.
Okay.
And that's somebody who you're not giving any real responsibility to except for one thing: fire the trustee if the trustee's not doing their job, and replace them.
Okay. Yeah, that's a complex issue there. That's very specialized planning, but it might be your kind of situation. Our goal today, we're talking about estate planning, and much more, is really to bring up topics that are things that I've seen in my practice with clients and questions they have. And what we try to do our very best is give people good answers, but it all starts with individual meetings, finding about their situation, and then we lead into meetings with the attorneys and we bring in the final solution. That final solution, let's say you've done wills and trusts. 5 years from now, we should review with you, 10 years from now, or is there special events, or what kind of recommendation do you have on someone who already has documents?
If that were a multiple choice, it would be D, all of the above.
All of the above,
because
okay.
5 to 10 is my sweet spot. That's exactly what I say to people.
Sure.
And they worry, oh, that means I'm going to pay another fee. And I say, don't worry about it. Just call me up and say, hey, Kevin, I'm your client. You have my file. Take a look. Should I be changing? Did the laws change that would affect me?
Right.
And then clearly, if there's a change in family circumstances, a child, heaven forbid, is diagnosed with sort of a long-term care problem, then you want to maybe talk about a special needs trust.
Right. A special needs trust is another thing that is done for children, adult children, where you want to provide for them. But you don't want to give that money outright to them by putting their name on a beneficiary, because then that would forfeit their benefits that they're receiving.
Or if they have a disordered bipolar, they may just blow through the money, in a fit of not thinking straight.
Or an addict of some sort.
Or an addict.
Yeah, trying to take care of that. Now, when I'm thinking about charities and giving money to charity, that is something that can be done through wills, trusts, or by beneficiary. Is there any more efficient way?
Wills, trust, or beneficiary. I mean, I like wills for that because there are some variables to build into the will, like provided the charity is still in business. And you don't see charities fold up too much, but some get merged into another charity.
Sure. If you go through a will to do charity, is there estate taxes, or is the charitable, if it all goes to charity, then there wouldn't be?
If it's a legitimate 501c3 or other subsection there. But you have to be careful, because some people say my alumni association. Well, they may not be a recognized charity.
Right. Okay, that makes sense. So the idea here is there's a lot of issues when it comes to estate planning. And what you got to do is plan for your situation, your family situation, and what your wishes are. And that's why you need to work on these kind of things. Earlier, I mentioned that I believe greatly that we need to plan as if we might die tomorrow or be disabled tomorrow, and invest like we're going to live forever so that our money will last a lifetime. That's proper planning. And that leads to where your retirement is truly winning in retirement, because you have everything handled. And that's what at Akers Financial Group, we want to walk you through the planning process of making sure things are set up the way you want and or need it to be, to make sure the beneficiaries of your choice get the money at the timing that you set up. So the best part of retirement is getting your time back. Where you decide how to use it. Your time is no longer tied up with other commitments, mainly your last job. A lot of that goes away in retirement. Your time is consumed by things that you want to do. So it's so easy to begin winning in retirement. Go to our website at akersfinancialgroup.com. And right there, you can scroll to schedule a meeting section and let us know you'd like to schedule your free consultation with one of our team of advisors. That's akersfinancialgroup.com, or call us at 833-WIN-RETIRE. That's 833-WIN-RETIRE. We'll give you a call on Monday to schedule your free in-person meeting. So go ahead to akersfinancialgroup.com. Family, kids, and legacy. How to provide for each. We'll cover this in a moment.
You're listening to a pre-recorded show. Welcome back to Winning in Retirement. Call 833-WIN-RETIRE now to schedule a visit with Brian and his team and begin winning in retirement. Once again, here's Brian Akers.
Welcome back to Winning in Retirement. I'm Brian Akers, certified financial planner practitioner from Akers Financial Group. Here with me today is attorney Kevin Bress, who I've known for many years. He's an expert attorney on practicing in the area of estate planning. It's been more than 40 years, I believe, and he's from Bress Route Law, LLC. And we welcome Kevin to the fourth quarter. You're still okay? You don't need a break?
Coming down the home stretch, I'm in good shape.
We call this winning time on this show because we got to bring it all together and get the points across that we desperately want to get across.
You're the man.
Well, So are you, and we enjoy having you here because it's a lot of fun. Now, Kevin is so much older than me. It's most shows I'm the older one, but on this, that's okay. Kevin and I do have fun. We've had a few public seminars together. That's been fun. But this topic of the fourth quarter is one that I think is great, and there's no way we can cover it all in our 10, 12 minutes here. Family, kids, and legacy, how to provide for each. So family, kids, and legacy. So we can just start out simply providing for your family through legal documents. If you don't mind just covering ideas on how to provide for family or things that come across your mind of concerns or mistakes people make or...
Yeah, usually just 3 goals I try to winnow it down to.
Nice.
Taxes, which we pretty well beat up good in the first couple segments as goal 1. Goal 2 would be that the assets pass smoothly, quickly, and that's the probate versus non-probate, trust versus beneficiary designation. Right. So that's a conversation to have to pass them quickly. And then the third is protecting the heirs from themselves. And this is something not too many attorneys bring up, but there's 5 Ds of what can go wrong with your heirs. They can get divorced. They can get disabled. They could die and leave the money to the wrong people. They could have debts and go get sued, or death taxes. So I coined the phrase, the 5 Ds of what can go wrong.
Coined it or trademarked it? That was pretty nice.
Yeah.
Can you cover the 5 Ds again?
Okay. Divorce.
Divorce. Okay. And that's if your child gets divorced.
And your inheritance legacy goes to the in-law.
Okay. And that mistake would be if you give money to your child and then they commingle it with a current spouse and then get divorced. Is that fair?
That's right.
So divorce, what's the second D?
Disability.
So disability. Now, why would that be a concern?
Well, if you knew, let's say you had a heads up and you knew your child was suffering from a serious medical...
Yeah, a long-term debilitating disease, there are certain things to look at, right?
Right, and they're already being taken care of. Maybe they're in a group home. Maybe they're on Medicaid. Maybe whatever they're getting, it's adequate. Well, why leave them money only to kick them out of those programs, including the group home that they were settled into?
Right. What's the third one?
The third one would be debts. Like they get sued.
Okay.
They go bankrupt. And so your legacy won't be counted in that lawsuit to pay the debt. The fourth one would be death. Okay. You don't want your in-law to inherit the money from your child, especially if it's a family farm, a family unique asset. Yeah. You want to leave it down to the grandchildren.
And what's the one that I forgot?
Death taxes.
Death tax. Also death and death taxes.
Correct.
Okay, the double death. That's what you did there. I get it now. Okay. Death taxes is the fact that upon a death, there could be not all the money goes to your heirs. There's the federal government or a state government might want to collect.
Or your child's a multimillionaire, and now you're just adding to the problem by giving them your money.
Correct. I've had many issues when it came to estate planning. People that they come in after the fact and talk to us, and I always wish I could go back and fix things, but I can't. And a lot of the mistakes lead to where they act on their inheritance. They act on things before meeting with an advisor or with an attorney. They accept money from a retirement account. The parents might have retitled their house in the joint name with the child. It was like a farm they had in the family for 50 years, and all of a sudden, right before they pass away, they switch it into joint name. And just simple things like that are just big mistakes that I found in family planning that I try my hardest in these talks to be able to get across, plan it out, plan how you want to do it, what's the most efficient way to do it, and to make sure we don't pay taxes that we don't really have to pay.
Totally agree, especially the long-term care issues. Yeah.
Long-term care issues, that's the disability, and the disability that will lead towards where you need to be provided for on a day-to-day basis. The health insurance doesn't cover it, so your assets have to cover it. And when we have that situation, that could lead towards your assets going down by 100, 120,000, 150,000 a year. And so there are ways to handle that. And that's a separate part of law called elder care planning.
Yeah, and elder care is a misnomer because it's really disability of somebody.
Because no matter what age, right?
That's right.
Okay. Okay.
But another issue, Brian, in that area is who's going to be the trustee of that special needs trust.
Yes.
Is it a brother or sister? Sometimes the parent says, I don't want to burden my son or daughter to be the trustee.
Right.
Well, Maryland has a charitable organization that will serve as trustee of a disabled person's trust. It's called First Maryland Disabilities Trust, and they're down in Lutherville. So that's a great way to have all that child's needs overseen by a philanthropic organization.
That's very interesting. I have not used them. I guess you've used them in your career.
I've sent people to them.
That's good. Yeah, I really believe that the Special Needs Trust is just a way to help families and a way to help them help their family when they know they won't be around to help. And that's a very, very good thing to do. And a lot of people do need to look into that when they realize and draw sort of lines about their family members. And there might be somebody in your family that needs specialized planning in the estate documents.
Exactly.
Now, I was talking about family and kids and legacy. Legacy to me is it's really about what you're trying to give to that next generation or give to your community or to your what you believe in. The hardest part is I wanted to ask you is what do you call legacy when you're dealing with estate planning? What do you consider legacy?
Well, I've seen the gifts to, say, Upper Chesapeake Hospital. I mean, that's a substantial gift where something's named after you or a fund is created. I don't know, Brian, if you've had clients look at donor-advised funds.
Yes.
That's a really neat way to do a legacy, and you can keep your kids in charge. You're basically earmarking your money for charity, but you haven't given it away yet, and the family can be in charge of it.
Yeah, we've done that. I had a couple of private foundations over time. Charitable giving and generosity giving is something I really love and enjoy talking about that. The legacy that people have, it's always individual of what they want to accomplish after they've been so successful. Some of the hardest things we have is where people want to give to charity, and so they put that in their will, and then I really want it to come out of their IRA. And so when you're, as a lawyer, how do you know the beneficiaries of the IRA? I mean, IRA, they can change any time they want the beneficiary, so it's not like a permanent decision.
No, I have a fact-finding sheet, and it's up to them to tell me. But as you say, they could. I don't stay in touch with my clients every month or year, so they could change it, not realizing there was a smarter way to do it, as you're describing, income tax avoidance.
Yes, if I can give my kids things that are not income taxable upon a death, and then the things that are taxable, give those to charity, I've reduced the overall legacy taxes on the whole thing.
And the big change, Brian, that you're probably talking about is that you used to be able to give IRAs to children and they could stretch keeping that IRA over their lifetime.
Correct.
Now it's a 10-year dump it out rule, and they have to accelerate when they're going to pay the tax. Yeah. That's when the charity starts to look really good as the beneficiary.
Oh, and the rules got real complex. If you split your beneficiary between spouses, kids, and charities, there's all these special calculations. You lose the 10 years if a charity's involved. The charity needs a separate IRA, not a combined IRA. The spouse needs a separate IRA, not combined with kids. That's all happened under Secure 2.0.
I'll have a map to your office to give the clients when that happens.
Well, we have maps, a flow chart for that, because a flow chart is really a flow chart. Well, I call it estate flow. That's where we write down where people have their money. We write down the beneficiaries, and we say, well, this is who's going to get what and how much. And then we talk. Then we have these calculators that tell us the taxes for each person that based on the way you decide. And then we say, well, can we reroute you? Is there a better route to get you that destination? Because the hardest part is really listening to the client. It's almost like going on vacation. Where do you want to go on vacation? And then we come up with all the different, not triptychs, but the concept of which way do you get there? How do you get there? And I like to take the path without the tolls. Just like on your GPS or ancient GPSs, you put without the toll. So if we can avoid the toll in estate planning, I believe estate planning is done right. I love being able to meet with a client's family after my client passes away and say to them, my clients did a really good thing of saving money for you. Their goal for you with this money is this, and this is what they told me while they're alive. This money is to help you with these needs, and this is how they wanted you to do it. And then we guide each kid, each person that's receiving it into that. If it's charity, we deliver the money to the charities. We hands-on helping that legacy actually happen for our clients. And that's a big deal. And as a lawyer, you guys do the same thing, right?
Yeah, and it's just very refreshing that you're having these conversations, because I can only go so far in implementing what I'm describing. And so that's where the overlap occurs.
Exactly right. Many people get documents and just go file them away. A lot of these revocable trusts, they'll file them away and they won't even retitle. They won't even use it right. So one of the things about financial planning is we ask a lot of questions and then we implement and make sure it does what it's supposed to do. And I believe it's a simple concept, but it's not done for everybody, and that's a shame. So, Kevin, I thank you very much for putting up with me today and listening to my questions and giving us the great answers. Now, this is advice that we love for people to consider going to an expert, going to a financial planner, going to an estate lawyer, and truly letting them understand what you want so that they can deliver the right answer for you and your family and for your legacy. So that's what we covered today. You can go to AkersFinancialGroup.com, check us out there, and you can hit the radio podcast tab and hear this show again, or go to any podcast area to get that same information. We do look forward to meeting with you. We want you to be winning in retirement, and we want you to take advantage of the opportunity to begin planning with us at Akers Financial Group. To schedule a free meeting with one of our team of advisors, go to our website at AkersFinancialGroup.com. Scroll to the schedule a meeting section and let us know you'd like to schedule a free meeting right there. That's AkersFinancialGroup.com, or you can call us at 833-WIN-RETIRE. That's 833-WIN-RETIRE. We'll call you on Monday to schedule a free in-person meeting with one of our team of advisors. Start planning now for your retirement. Go to AkersFinancialGroup.com. Call us at 833-946-7384. Thank you for listening. I'm Brian Akers from Akers Financial Group, and we want you to be winning in retirement.
You've been listening to Winning in Retirement with your host, Brian Akers of Akers Financial Group. Akers Financial Group offers securities through Arcadios Capital, an SIPC and FINRA member firm. Advisory services are provided through Arcadios Wealth. Akers Financial Group and Arcadios do not share any common ownership. Neither Arcadios nor Akers Financial Group provides tax or legal advice. Advice given on winning in retirement is general in nature, and one should seek further advice from their financial advisor, broker, attorney, and or tax accountant before investing. Be sure to read each prospectus carefully to understand all the risks associated with each investment. Examples and scenarios shared are meant to be for illustrative purposes only. Past performance is not indicative of future results.